tickets and fines, and is now significantly supported by a decision of the Cheshire Superior Court on March 1st, 2012, that Justice John Arnold of Cheshire Superior Court, number 1, Representative Keys.
Well, yeah. Well, first of all, you started with something that the other party had not responded. Do we know that our party was ever actually contacted?
Well, the named parties are
Did you actually contact that other party?
Yes.
Okay,
Yeah.
okay, because there was some question early on whether the ex-spouse had...
The ex-spouse isn't one of the other parties. The ex-spouse is unrelated to the charges. The redress is against public officials. We don't identify or contact spouses. We contact the official that's named.
Well, we already know that we have a ruling from the Attorney General that no public officials will be walking through this door, right? So
we have a statement that they will protest, et cetera, et cetera. Wait a second. Wait a minute, Representative Willett.
That was only on the one case that we got that one.
We have notification of a disinclination to cooperate from the AG's office for sure. Representative Harding.
The authorities do have the right not to testify. They, so they have the same right to self-determination that any other citizen of the state of New Hampshire or Arkansas or any other state of the United States has. So we're kind of crossing a gray line by somehow saying they're tacitly admitting guilt by not coming for defending themselves. And
Yeah, we're not actually saying that or implying that. Representative Willett. I'm sorry, Representative Lambert first.
Mr. Chairman, thank you. It's my understanding that the House, as a whole, has voted this committee the ability to subpoena, but we have not subpoenaed anyone. If it were, we have subpoenaed people.
we can subpoena documents.
Can we not have sideways conversations between the prosecutor?
Mr. Chairman, we have not subpoenaed people to this point. And a letter from the executive branch advising potential employees of the state to not comply with a subpoena issued by the House, if that were the case, would be grounds for us to go and make a request of the House for impeachment of the appointing authority and the individual in question. So if they choose to go that way, I believe that this committee can properly respond. But until that is the case, a letter from the Attorney General suggesting that public officials need not comply with the Constitution seems problematic and evidence of a weak executive branch. Just.
Representative Willett.
Thank you. I like to get down to the nitty-gritty. Nothing in that statement is false. There was nothing in that statement that we just read is false. As far as I'm concerned, I think it's important to be in this state. They had the opportunity to come. They knew what was happening. It wasn't done at midnight. I think that statement is true and should stay in this state.
All right. Thank you, and let's see if we can proceed to the points. So number one was that Judge Arnold unlawfully terminated contact between petitioner and his daughter for 2 years and 9 months in violation of his natural and constitutional rights to impart his religious beliefs to his daughter. You have, now this is expressed here as a statement of that is the single reason that that decision was made. Is that the case? And at any rate, do you have documents to show that the decision is based on a religious beliefs position in part of it?
I have documents that show that it was an unlawful order, an order of March 1st, 2012. Cheshire Superior Court ruled that it was an unlawful order that terminated contact. It was the lack of due process is the problem. And I have copies of that here.
Okay, good. That would be great. So that's the 2012 decision that just came out this spring, and they make that statement.
That's correct. The court itself,
Right.
different judge, of course.
And so this is supported, and it'd be useful for us to express that here. This is supported by that decision. this statement is supported by that decision, it's not just a
Yes,
statement.
and I believe I gave you what are called the moving papers, which show that the reason that was given the court why the contact with my daughter should be terminated was, among other things, religious practice, prayer, reading the Bible, those types of activities. I believe you have
That would have been in your motion.
that was in the guardian ad litem's motion. I believe I
Oh,
gave
in
you
the
that.
motion of the guardian ad litem, okay, right. And so you believe we have that in our file?
I'm pretty sure I sent that. I have copies if you need it, but if you don't have it.
If you have a copy there that's not an original, we can look at it. Would you pass those two things and just give them to Representative Hogan, and she'll just look at them and pass them if you would, Representative Hogan?
So let's, under number 2, respondent's motion to vacate the order. It's about a page in its entirety.
And if we could, would the folks not let those get plugged up in their area so that they get officially down back to the other end where Representative Lambert and back to the petitioner? These are not, you didn't bring these in for us to keep, we presume they already have these.
You can, yeah, those are for you to keep.
Okay, all right, and by the time they get back to Lambert, there'll be a nice stack. Thanks. And nice to have you here today, by the way. All right. And by the way, we have a stand-in today for Representative Hardwick in the petitioner sponsor for the Capen position. I took advantage of it in the absence of a forum. So, just willing, so thank you, Representative.
Mr. Chair, the timeline of when we're going to get to the Capen petitions, and so Mr. Vandenberg's presentation, the previous presentation went on for 4 hours. So
Well, at the rate of side conversation today that we're going on, I'd suggest that it'll be about 4 o'clock this afternoon. I'm going to stagger it away.
we had an unfortunate.
But it won't be happening that way. We'll be done before noon. I'm sure this looks like there's no reason why it's going to be incredibly efficient. We also had that in another petition that was similarly extended. So, Representative Hardy?
Yeah, we had an unfortunate situation last time where petitioner and sponsor are all set up at this table ready to go, and they have to wait.
You know, I really appreciate, I know the cameras are running, I appreciate your tracking maybe every opportunity, but I think they're Hardy, I appreciate it.
Mr. Chairman.
Representative Hubbard?
In the interest of efficient editing of this document, and I hate to question your procedure, but I would be curious if people had suggestions for edits to this document, if we might ask for a collection of those and to bring back, have a quick discussion about the proposed changes and bring back another copy for everyone. This interactive editing of sentences tends to take a long time, and I'm just suggesting that just because this is a 2-page document. And it's just a theory.
Yeah, well, actually, if this was printed in 12-point Roman, it would be a page and a half or less document, but I think I have to proceed the way I can. I can see clearly to do this, I can't see clearly to do it that way. I can't see necessarily success that way, but
Okay.
to any extent that anybody actually has hard proposals and have them ready by the time we get to the end, or at the place the points come up, that would really be excellent. Representative Capper, did you want?
No, I was just hoping we proceed.
Yeah, let's proceed. That's what you're here for, is make sure we can proceed. All right, so let's point 1 is in the Fit 2, Judge John Arnold failed to enforce mandatory directions to putatively appointed guardian ad litem Judith Hamilton. Putatively means he's in doubt whether that person was actually, we certainly could use maybe a more everyday word for that, but it means that there is serious doubt and evidence that that person is actually not properly appointed. So failed to enforce mandatory directions. Do you have copies of what the mandatory directions are and show us the evidence?
Yes, I believe I gave those to the committee already. It's administrative
I'm sure you
order.
didn't, by the way, you don't have to keep saying that, I'm sure it's here, but because this has gone so long, we're hoping that you will actually bring it to our attention separately.
There is Superior Court Administrative Order 17. Which I have a copy of here.
So that should have been referred to up there before we got down that second, shouldn't it?
Yes.
Let me move that up in the text here.
It's referred further down.
Right, I thought so. Okay. So,
These are the 2 orders, administrative orders.
what was that? So you're giving us the copy of what they're required to do, and what is the evidence that we're looking at that the judge didn't do that?
Well, it doesn't exist, so you can't bring in something. What needed to occur was, firstly, a report. Upon appointment, a guardian ad litem is required to produce a report according to both of these administrative orders. And another court case, Ross versus Godwin. And the second thing is stipulations, which is the contract. And the March 1st order that I think Representative Horgan might have states in there that no stipulations were ever provided by the guardian, so-called guardian ad litem case.
What states that?
So the order of March 1st, there were never any stipulations provided by
Okay,
the
so that's
guardian.
also content provided in the statement of that Cheshire court decision.
That's right.
Right.
And that is
That's the main support we're looking at.
right. So that's the one document that says it was not done. And then again, we don't have a document that says the report wasn't done, we just don't have any report.
Yes, okay. And we've run into that before, but in this case, you're covered nicely by the report. All right, any questions on that point? Point 3, and you did your documents, okay. So you're going to look quickly and pass, right, Representative Wood?
Yep.
To keep the business going. 3 is improperly granted Judith Hamilton's motions to exceed the mandatory fee cap of $1,000 by at least $11,069 without the requisite hearings demanded by the Superior Court Administration or the same order. Now should be that phrase is going to go up north after the other previous one, and we're going to use the phrase SCAO 17 and FDAO, which I don't have a phrase for. Is that a federal?
No, Family Division Administrative Order.
Yeah, I need that. Okay. Okay, and so now you've provided us copies, or you have copies of those proofs?
Right. What I have here is a copy of her bill that she received those amounts of money. She actually received a bit more, but those are the ones that are referred to.
And these are, you know, to refresh my memory on this, these were monies that were billed to you and paid to you without ever having a hearing. Is that what we're saying here? They're probably granted.
The first amount was billed without having a hearing. The second amount was billed and granted without a hearing. So they were both granted without hearings, which is, according to both of those administrative orders, in order for a guardian ad litem to receive fees, there has to be a hearing. And that's in those two orders that are going by. Superior Court Administrative Order 17, Family Division Administrative Order 2005-01. They both, it's just identical language. They both state that there has to be a hearing to raise a guardian ad litem fee cap. The fee cap is $1,000. There has to be a hearing with the parties present, the guardian ad litem present. None of that ever occurred. And I have the orders.
Is this the same support as essentially that of the court as well? The court, later, the March 12th, March 1st, 2012 court order?
Yes.
That's also supported there,
It states
right?
in there that the guardian ad litem did not submit timely motions to exceed. So her applications to the court to increase her fee was never timely submitted to the court.
Timely